Welcome back to Real Estate 101. Today we're going to continue our discussion on family law and talk about how to change a support order. And I'm pleased to be joined once again by John Schuman of Devery Smith Frank LLP. John, welcome back to the show.
Glad to be back.
All right, John. So if someone loses their job or they get sick, can they just stop paying court-ordered support?
No, court orders continue until they expire or until they've been canceled by a court. So if you stop paying support under a court order, you're in breach of a court order. And in Ontario, we have the Family Responsibility Office, and the Family Responsibility Office enforces court orders, and they will continue to enforce the court order until it either expires or a judge tells them to stop. So you'll have to keep paying support as long as that court order is in place.
All right, so let's say there is no court order and it's just something that's in your separation agreement that you're going to pay support. Can you just stop paying?
Agreements are very close to being the same as court orders because you can actually, or any party to a separation agreement can take it to the court and have it enforced as a court order. So if you want to stop paying support that's in a separation agreement or another sort of domestic contract, you have to go to whoever you're owing the support to, and you have to ask them to sign another agreement to say it can stop. If you don't do that, that person can take the agreement that you signed, take it to the court office, just file it with the court office, and the court office will start enforcing it like a court order, which means you'll have the family responsibility garnishing your wages or your banking accounts or whatever to collect the support that you're not paying.
All right, so let's say that person did lose their job and they're supposed to be paying support. What can they do?
Well, they have to go and change the court order. Now, if you did lose your job or you're sick and you can't work anymore and the support recipient knows that, and they agree to change the support order, then it's a very simple process to change the support order. You just go to court, you don't have to appear before a judge, you both have to sign some court papers and file with them in court, and then it'll go to the judge in their chambers, and the two of you don't have to show up for court. If it's a child support order, you actually have to do it's a shorter version of a financial statement to show what your income is, and you have to give your tax returns as well to show what your income was, because judges have a lot more responsibility when they're changing child support orders to check into people's income. But it's a very simple process if you both agree, and no court's involved. If you don't agree, then you do have to go back to court and start a new court proceeding. But the court proceeding to change a support order is much more simple than the first time you went to court. The new process for changing an order, there's usually only two steps. You have a case conference and you have a motion where the judge hears the arguments, all the evidence is by affidavit. It's not a trial again. It's just evidence by way of affidavit, and the judge makes a decision, and it's usually done in like an hour or so. So you have like 2 hour-long court appearances, and the judge will decide what the support should be changed to. If there's real contested facts or a big argument, you might have to go back to a trial. But again, judges try very hard to make the changing process a much quicker process than the original court proceeding was, because a lot of the stuff was either finalized or established in the first court process.
All right, so do you need a lawyer to help you with this paperwork?
Well, technically you don't need a lawyer. You can go print off the paperwork online and figure it out on your own, but there's some real pitfalls to doing that, some traps. And judges don't like lowering support. Especially child support, they don't like lowering child support. And they expect people to sort of get back on their feet if they can. And they don't like, cutting kids off when they're dependent and giving them no support whatsoever. And they really don't like people who are dependent on spousal support to be cut off spousal support. So they can find a lot of, technical legal arguments to avoid cutting off support. And you really need to address those when you're asking a court to either stop support or lower your support. And you're not going to know those unless you speak to a lawyer. So having a lawyer can really help you fill out that paperwork. It can also usually make the process go more smoothly, because the lawyer knows how to get you through it more quickly, and you're not going to be stumbling around trying to figure out what the next step is or how to book a court date.
All right, so let's say your ex tells you not to bother with court, and not pay child support for a while. What then?
That's a really dangerous thing to do. If your spouse says that, you really want them to put it in writing. You want them to sign that agreement that says that he or she agrees that they're not going to get child support anymore or spousal support, or they've lowered it. Because if they don't sign that agreement, then that person feels sorry for you this month, but next month, I'm short, I need to pay more bills. They take that agreement to the court, and they and they file it with the court, and the court starts enforcing it, or they ask the Family Responsibility Office to enforce the full amount of support. And when that happens, there's no change to the order, there's no change to the agreement, so they're going to come after you for the full amount, even though you're going to say, well, she told me I didn't have to pay. Or
It's going to look like you didn't pay, yeah.
it's going to pay, and the support recipient's going to get all the money that you didn't pay plus interest. So it's a dangerous thing just to take someone by their word. If there's an agreement or a court order that's in writing, you really need another court order, you need another agreement in writing to prove that there's that agreement to change the support.
All right, so what if it's a separation agreement as opposed to a court order that needs to be changed?
Well, if you agree and it's a separation agreement, you don't have to go back to court, obviously, because you can just sign a new agreement that says that the support is changed. If, however, the person who's receiving support doesn't agree with the change, then you have to go back to court. And there's an easier way of doing that. You just take the separation agreement the same way the recipient would have done if they weren't happy with the fact you weren't paying support. You take it to the court, you file it with the court, and then you bring in, it's called a motion to change. Again, it's a simplified procedure, and you ask the court to change that agreement. And then you have a short court process, the same way as with the changing a court order, to change the agreement and lower support.
So can you just stop paying support while you're working out what the change might be?
No, until there's an agreement or a court order, you have to keep paying support pursuant to the last agreement or court order. Otherwise, you're in breach of the agreement or breach of the order, and your ex can go and ask the Family Responsibility Office to enforce all those missed payments, and they will collect them. If at the end of the day you overpaid for a period of time, then a judge can order, or you can agree in agreement that you get some sort of credit back for the support that you overpaid. But until that change is in place, you need to keep paying support, otherwise you get yourself into some trouble.
All right, so what if your ex is saying no to the change for no reason? Are there any consequences for someone to try to keep getting support when they're not supposed to be?
Yes, if the circumstances have clearly changed, judges don't like it when people keep trying to collect support when they're not entitled to it. That is especially true of child support, when a child is either no longer living with the person who's receiving support, or they've stopped going to school full time, and child support has a very clear end date when those things no longer apply. So judges get really upset when people continue to try to collect child support when it's not for the child. The same thing goes with a bit with spousal support, because if a person's income or situation is really deteriorated and it's clear they can no longer pay spousal support, and they're actually paying support to someone who makes more money than them, they just get really upset if that person doesn't agree to reduce the amount of support. And the consequence is that there are costs, and the judge can order that the person who unreasonably said no has to pay your court costs, your lawyer's fees, all the things you paid out to get that agreement or that order changed in court. And that can be a big hit.
Okay, so is there anything someone should do to make sure that the judge changes the support order?
That's another good and important question, because as I said, judges don't like changing support orders. And if a person has a temporary dip in their income, judges don't want to change a support order. So what you have to show is that if you have lost your job, you're going to get severance for a while, hopefully. And that severance is income on which you can pay support. So for as long as the severance is going on, or is the period the severance is supposed to cover, you should keep paying support. And during that time, you should be trying to find a new job. So while you're trying to find a new job, you should be looking for a job that has a similar level of income. So that if this is just a blip in your life, you're going from one job to another and your income's not changing much, then your support's not going to change. So if a judge wants to see before they lower support that that's not the case, that your income is down permanently, at least for a long period of time. When you go to a court to say, I want my support reduced because I lost my job, you have to show you applied for a lot of jobs. You applied for a lot of jobs that make about the same amount of money as you did before, and you didn't get any jobs, maybe you didn't even get any interviews. And the only jobs where there's any interest is ones where you're getting paid a lot less. And the judge can see that you're only getting offers that pay you less, then the judge is more likely to lower support. But without that evidence, the judge is going to be really skeptical about whether or not you're just lowering your support for a period of time, and as soon as the judge changes the order, you're going to go back and earn what you did before. The same thing sort of applies if you're off because you're sick or you're injured and your income goes down. The judge is really going to want to see some proof that you are actually sick and you're injured, and it's serious enough that it's going to impact your income earning ability, and it's going to go on for a period of time. Like if you're off for a month, the judge is not going to change support. But if you've got some proof that you're really sick and you're going to be off work for a good period of time, then the judge will lower support as long as the medical evidence is there to back it up.
All right, so let's turn this around. Let's say you are receiving support and you think your ex is making more money and you should be getting more support. What can you do?
Well, it's basically the same process, but in sort of in reverse. You can go back and ask for a new agreement if you have an agreement, or you can go to court and ask for a change to the order. And if you don't agree, you can file the agreement to have it changed with the court, or you can just go to court and ask for a change in the court order. With regard to child support, the changes based on someone's income are supposed to be pretty much automatic. It's supposed to change like every year based on the payer's income. If that's assuming that the children live only with you. But whoever the children live, that person, the other person, that person's change in their income triggers a change to child support. It doesn't even matter really how small the change is. It's supposed to look at the tax returns every year. If the person who's paying child support does not hand over their income information and the person who's receiving support doesn't know their income has changed, that can be a big problem for the person who's paying support, because there's an obligation to provide that information about your income every year. And if you don't provide that information every year and you're the support payer, as soon as the other person finds out that you haven't paid the right amount of support, your income's got up, they see you driving a Ferrari, whatever, they go back to court and say, I didn't get any income information. The court's going to order that the support be paid back, increased retroactively to when your income actually changed. And if it's been a few years, that means you can end up owing a lot of back child support. And there may be interest, and the judge may ask you to pay costs, because judges really don't like it when people don't pay their child support. Spousal support's a little bit trickier because it depends a lot on what the order says and what the agreement says as to when it can be changed. But if the order agreement allows it to be changed because someone's situation has changed, then absolutely you can go back as soon as you know the situation has changed and ask for an increase in that spousal support. Unless, of course, the order agreement says you are not allowed to get any more changes.
All right, John, so any last tips on changing a support order?
Well, if you're not sure if you're going to get a change, if the support's not going to change, then you should speak to a lawyer. And you can call me and ask me, and we can set up an appointment and we can talk about it. Or if you think that the whole process seems a bit daunting, or you're not sure what evidence you need to do or how you're going to prove it to a judge that the income has changed, then again, speak to a lawyer. We're always happy to have a consultation with you. You may hear everything you need to know in the consultation. And we help with filling out all that paperwork, because what you put in the paperwork and what a judge reads in the paperwork can be really important, especially in these cases where the judge is on changed cases. Judges rely more heavily on the paperwork because they don't have witnesses in the box. So having someone who is really good fill out the paperwork really helps you get a change in the support that you're looking for. So again, contact a good family law lawyer, and I always encourage people to contact a certified specialist in family law like myself.
All right, John, great stuff. Thanks for coming on today's show, and I'm looking forward to seeing you again next month.
Thanks for having me.
So if you need some help changing a support order, get in contact with John Schuman of Devery Smith Frank LLP. I'm Joe, thanks for watching, and we'll see you next time.